Welcome to Jurisedge Academy's YouTube channel. In this video, we are going to discuss important weekly legal update from 24th January to 29th January 2022. In first important news, the Supreme Court has quashed the Maharashtra Assembly's resolution to suspend 12 BJP MLAs. In the case of Ashish Shelar versus Maharashtra Legislative Assembly, the Supreme Court has quashed the Maharashtra Assembly's resolution of July of suspending 12 BJP MLAs for a year. The court has held that the resolution to suspend the MLAs beyond the session is unconstitutional, illegal, and beyond the powers of the Assembly. The court has said that it has declared that the resolution directing suspension beyond the period of the remainder of the concerned monsoon session held in July 2021 is non-est in the eyes of law, nullity, unconstitutional, substantively illegal, and irrational. Therefore, the court has declared it to be ineffective in law. In next important news, the Supreme Court has held that equal pay for equal work is not a fundamental right vested in any employee. It is a constitutional goal to be achieved. In the case of State of Madhya Pradesh versus R.D. Sharma, the court has observed that equal pay for equal work is not a fundamental right vested in any employee. However, it is a constitutional goal to be achieved by the government. The court has made these observations while holding that the equation of post and determination of pay scales is the primary function of the executive and not that of the judiciary. Therefore, ordinarily, courts will not enter upon the task of job evaluation, which is generally left to the expert bodies like the pay commissions. In third important news, the Supreme Court has held that mandamus cannot be issued for providing reservation. In the case of State of Punjab versus Anshika Goyal, the court has said that no mandamus can be issued to the state government to provide for reservations. Therefore, in the present case, the court has held that the High Court has committed a grave error in issuing a mandamus and directing the state government to provide for 3% reservation for sportsperson. A conscious policy decision taken by the state government cannot be changed by issuing a writ of mandamus to the state government. Lastly, the Supreme Court has held that neither the client nor the court are bound by the lawyer's admissions as to matter of law. In the case of Employees State Insurance Corporation versus Union of India, the court has noted that neither the client nor the court is bound by lawyers' admissions as to matters of law or legal conclusions. The court has said that while generally admissions of fact by counsel are binding, neither the client nor the court is bound by admissions as to matters of law or legal conclusion. A lawyer generally has no implied or apparent authority to make an admission or statement which would directly surrender or conclude the substantial legal rights of the client, unless such an admission or statement is clearly a proper step in accomplishing the purpose for which the lawyer was employed. Lastly, we have an announcement that we are organizing an open mock competition on 6th February, that is Sunday, between 3 to 5 p.m. It is a mock for CLAT PG 2022. The registration is entirely free. It is designed on the latest pattern, and you will be getting an All India rank as well as detailed analysis of the mock. Link for registration will be dropped in the description box. If you like this video, please like and share and subscribe to our YouTube channel.